tracking the matters specified in the Bill of Particulars on the perjury indictment are the areas that the defense is seeking to limit the testimony. It seems to make sense to just first go through some of those areas, because some of them are ones that, on unrelated reasons, may not be inquired into or may not have an evidentiary basis of relevance so.
Yes, Your Honor, I didn't mean this list to be all-inclusive. To me, the all-inclusive list is what's in the Bill of Particulars.
Right, that's what I'm doing.
Yes, Your Honor.
I'm saying
yes.
But going through. So A through D, is the Commonwealth intending to go through A through D?
Right, Your Honor, I was just focused on the defendant's motion, so I don't have
right, but the motion tracks the Bill of Particulars.
It's attached as an exhibit.
Oh, it is, okay.
So,
Exhibit 2.
No, Your Honor, A through D, no.
E, that she did not have a conversation with Mr. Hernandez about why the police came to their home or why she went to the police. He went to the police station. Are you trying to elicit from her the failure to have a conversation?
Not the failure. What, if any, conversation that she had?
But she has testified she had none.
No, I understand that, Your Honor, but...
Right, so I will do a voir dire to see if that testimony changes, because if her testimony is still none, what would be the purpose of eliciting a negative? What would be the good faith basis for eliciting a negative?
Well, again, it would just be, I would be asking her questions about what conversation she had.
Right, and if you know that the answer is there was no such conversation, then under cases like Commonwealth versus Hart and cases cited in Hart, why can the Commonwealth ask a question of a witness that it knows the answer to is no?
But I don't know that. See, that's...
Well, that's why we can... Well, okay.
But again, Your Honor, that would be perfectly just to say, when she's on the stand in front of the jury, have you had a conversation with him? I mean,
right, but
she can equally answer then.
The Commonwealth believes that answer, no, is a lie. Because the Commonwealth has charged her with perjury for saying she did not have a conversation.
That was 1.5 years ago, Your Honor, when she testified. I suspect she's had plenty of occasions to speak to him since that time. So the question, did you have a conversation with him from that time till now?
Okay, so your question is simply, did you have a conversation with him subsequent to your grand jury testimony as to why the police came to the house or why he went to the police station?
Right, and I guess...
Okay, that's fine.
Yeah.
So E is limited. The Commonwealth is not seeking
well,
prior
the only thing I would say, Your Honor, is if... I just intend to ask her, have you had conversations, without really getting too specific, and let her say, if she says, no, I haven't, well, then fine, we move on. But the question is, if in fact there's been any conversation, let's assume she did have a conversation with him and then lied at the grand jury, and then subsequent to that time has spoken to him more about that.
Oh, sure.
Those two things obviously are relevant. So I'm not looking to just, if I ask a question, she says, no, I didn't, we're moving on.
Right, but to the extent it tracks the conversation, unless there's some reason to believe it's different.
But just because of the past, that's what I'm suggesting to Your Honor. There's been a lot of time since that time when I first questioned her, and if there was any withholding, or if there's been subsequent conversation, she's under oath,
sure,
and it would be her burden.
Right. So you certainly can ask her about any conversations post the grand jury. The question here is on a question that you asked at the grand jury up to that point in time, where she has already said no, unless she says something post the grand jury that sort of would activate that.
But what if that was not truthful the first time? Doesn't she have an obligation now to cure? If I say, well, have you had a conversation?
Oh, sure. And Sure, but the question is, the defense has said you haven't given the defense any indication that she's going to say anything differently, so we can do a voir dire with her on that.
But I guess that's what I'm objecting to, Your Honor. The voir dire, other than she's been immunized now.
Right.
And in fact...
But she was immunized last time, too, and made those answers.
But the penalties are different here. They're greater here. And she's also had the opportunity in the last almost year and a half to get all the discovery and understand what the evidence was. So if there was either misleading testimony, or not even misleading, but incomplete testimony, I should be able to ask her, did you have a conversation? And if there's something new from that time that she didn't share with us...
I agree. I think that she should be asked that in a voir dire to see whether there is anything new at all. And if there's anything new at all, you certainly can explore it.
But again, I'm just on the issue of the voir dire, that is typical for any witness to then be asked questions in front of the jury. The jury, if she says no, as I indicate, we're moving on, and they'll assess if she says no, there is something.
What isn't typical is for the Commonwealth to ask a question that they have indicated the answer to which is false. The Commonwealth believes that answer is a lie, to then elicit that lie, unless there is some reason to believe it is the testimony is going to be any differently. So we'll do it very short, not her whole testimony about anything, but just that very short one. She should, some of what she testified to when asked the generic question about, not about the police station, but conversations with Mr. Hernandez were classic denials, where she asked him, did you do it, or something to that effect, and he said, I'm innocent, I think that appeared a few times. That sort of classic denial testimony, which, apart from this, should not be elicited.
Well, again, Your Honor, as I understand, those pertaining to the post-Miranda denials, in conversations, some of the answers that he didn't know anything about what was going on, which clearly that answer would be...
Right, I'm talking about the ones where there were a few times where he says, I'm innocent.
I don't recall him saying, I'm innocent.
Well,
I think she said, I asked him if he had anything to do with it, and he said no.
Well, that's a denial.
Well, but again...
That's a denial, and the denial has been held, a denial is not consciousness of guilt. A denial has been held, that's a denial.
Well,
cases where someone has said, did you rape my daughter? And the answer is no, and the courts have said you can't get that in because that's a denial.
No, to the extent that that would be indicative of evidence that one, not post-Miranda, that
pre or post-Miranda, a denial is...
Making statements that are inconsistent with other evidence, that would be a suggestion there's consciousness of guilt. He's attempting to mislead her by that denial, saying he didn't know anything about it, if the jury found there was evidence at that time that he did know. So that is different than just a straight denial. It's being used to show his consciousness of guilt, his knowledge, and attempting to then, with other evidence in the case, use her for the purpose of thwarting the investigation, misleading her about what he actually did know.
I asked him if he did it. He told me no.
That's right.
That is a denial. Did you do it? Did you commit this crime? No.
And where there's evidence that he's doing other things and then misleading her about his extent of involvement and then asking her to destroy evidence, do things, make contact with the other co-conspirators, we say that's relevant.
In every case where there's a denial, there's other evidence. Otherwise, if there was not other evidence to prosecute the person for whatever the crime was, there would not be a trial. So all of those cases that say straight out flat denials are not admissible are all cases where there is other evidence that the denial is untrue. So a straight denial the court is excluding. The next one, that she had no conversation about murder in the investigation, other than the denial, again, if she has any new, if her testimony is any differently for the time period prior to the grand jury. Post-grand jury, you certainly can asked, but not, she should,
Your Honor, I mean, frankly, every conversation between Ms. Jenkins and Mr. Hernandez post her grand jury appearance in August of 2013 is on tape. I mean, they have a recording of it. So, you know, it just seems.
well,
I mean, clearly, if there was such a conversation, they would be offering it as evidence.
You said there were visits. Are those recorded?
Well, I think those ended once she was indicted, which I think was in September.
So there is a period though where there were visits.
Yes, there is,
The password to the phone, are you?
No, Your Honor.
That she did not understand the text message.
She's obviously going to be asked about the text message. That's in
Right,
evidence. Your Honor.
that's a separate issue. She certainly can be asked about the text message,
Well, to what extent
whether
she
she and Abiel, whether Abiel ever played with the box in the bath, and whether she ever destroyed a television. This is a narrower.
Well, Your Honor, that she did not understand.
This is her understanding, whether
That's
she
right.
understood or not.
So our position again is that she gave the answer she gave at the grand jury, and unless there's some basis, on the basis of a voir dire, to believe that she's going to say something different than she said before the grand jury, for which she was indicted by this district attorney's office for perjury, she may not be asked questions on that subject. It's improper.
It's not the subject, it's a specific question.
Well, Your Honor,
but it's a specific question whether she understood the text message.
that's right. Whatever H is, she cannot be asked that.
I disagree, Your Honor. I mean, obviously, he sends the text message to enlist her. And I think the court has even found it, or a reasonable juror could find, that the meaning was to destroy a piece of evidence.
Right, but what's
And-
her understanding?
Well, she's now a potential co-conspirator in that. So to the extent that she's asked, what did you understand that to be? I think, again, it's fair for